Hello and welcome to Courts This Week by LiveLaw. This is Advocate Ostika Das and I'm Debojit. Over the next few minutes, we'll walk you through the most important courtroom developments from the past week. The stories that made headlines, sparked debate, and may have lasting legal impact. So, let's get started. Our first story deals with religion, identity, and the contentious area of reservations. The Supreme Court held that if a person converts to a religion outside Hinduism, Sikhism, or Buddhism, they lose their scheduled caste status. So, what was the case about?
So, this case came from Andhra Pradesh. The complainant was born into the Marital community, a scheduled caste community, but had converted to Christianity and was working as a pastor. He alleged that members of a dominant community assaulted him and used caste-based slurs. An FIR was registered under the SC/ST Prevention of Atrocities Act, along with IPC offences, backed by a charge sheet, witnesses and a medical report. But the accused challenged this, arguing that once he had converted, he could no longer invoke the SC/ST Act.
So, which way did the courts go?
Both the Andhra Pradesh High Court and the Supreme Court agreed. The court relied on the Constitution Scheduled Castes Order 1950, of which Clause 3 restricts SC status to persons who profess Hinduism, Sikhism or Buddhism. Here the court said profess means a clear public declaration of faith, and his long-standing role as a pastor made it clear he was practicing Christianity. So the court held that conversion leads to an immediate and complete loss of SC status, regardless of birth.
But what about the argument that caste discrimination doesn't just disappear after conversion?
That argument was made, that caste is a matter of birth and social reality. But the court rejected it, relying on precedents like Guntur Medical College and CM Arumugam, and held that in law, caste-based disabilities are treated as tied to the Hindu social structure and are presumed to cease upon conversion. It also noted that Christianity in its theology does not recognize caste.
And what about the caste certificate he had?
The court said that doesn't change things. A caste certificate is administrative, but eligibility flows from the Constitution. So even if the certificate hasn't been cancelled, the SC/ST Act simply doesn't apply once you fall outside the definition. The judgment also clarifies that reconversion isn't automatic. A person has to prove genuine return and community acceptance. And interestingly, for scheduled tribes, the court says conversion doesn't automatically take away status. That depends on the facts.
That's quite a sweeping ruling, isn't it?
It is. And while it settles the legal position for now, it's already drawing criticism, especially from those who argue that caste-based discrimination continues even among converts, despite what the law assumes.
Now, a revealing ruling on women in the armed forces. The Supreme Court has flagged serious issues in how women officers were evaluated for permanent commission across the Army, Navy, and Air Force. What exactly did the court say?
So this is actually 3 judgments, one for each service, but the core issue is the same. For years, women officers were not eligible for permanent commission. We all know this. And because of that, the entire evaluation system, especially things like annual confidential reports or ACRs, developed on the assumption that these officers won't have long careers. So their performance wasn't assessed with long-term leadership in mind. Add to that the fact that many were denied key training courses and appointments that actually affect merit rankings, and you have a system that was structurally tilted against them.
And then once the court opened up permanent commission in early rulings, they were suddenly competing on the same records.
Exactly. And that's where the Supreme Court pointed out that this creates a real structural disadvantage because you're comparing officers whose records were built in completely different environments. The court also pointed out specific issues like the Navy not clearly disclosing how selections were being made, and in the Air Force relying on old performance records that were never meant to assess long-term careers.
So what was the court's ruling?
Because these officers have already been stuck in litigation for years, the court did not order a complete redo of the process. Instead, it said that the system they were evaluated under was fundamentally unfair, but at this stage, reopening everything isn't practical. So it took a more balanced approach. It granted pensionary benefits to offset the disadvantage they suffered, directed the forces to make future selection processes more transparent, and in the Air Force cases, it treated these officers as having completed 20 years of service, so they qualified for pension.
So our third story this week comes from the Supreme Court, which has raised concerns about something called post facto environmental clearance. Ostika, break that down for us. What does this actually mean?
Think of environmental clearance as a green signal you're supposed to get before starting a project, whether it's a factory, a mine, or a highway. So what's been happening instead is projects sometimes start without that permission, and only after they're caught, they apply for clearance. That's called a post facto clearance. Permission after the project is already up and running. And the Supreme Court is clearly uncomfortable with this.
But hasn't the court dealt with this issue before?
Yes, and that's exactly why this hearing is important. The court is currently hearing a batch of writ petitions challenging this entire framework. This comes after its earlier Vanashakti judgment, where it had barred post facto clearances, but that was later recalled on practical grounds like the consequences of demolishing completed projects. So now the court is essentially re-examining where to draw the line.
And what is the court saying in this hearing?
The concern the court is flagging is quite fundamental. It said if you allow post facto clearance, then illegal projects can just continue operating until the state steps in. And we all know that doesn't happen overnight. The bigger point is this: the whole environmental clearance process is designed to be preventive. It looks at things like cumulative impact, whether the area can handle another project, risks to water, air, nearby communities, even public consultation.
But once a project is already up and running, a lot of that becomes meaningless.
Exactly. As one of the lawyers put it, how do you turn the clock back on pollution? So the worry is that we are shifting from permission first, then project, to build first, ask later. And that weakens the entire system. At the same time, the court is also grappling with the other side, whether there can be some exceptions like public infrastructure projects where stopping everything may not be practical.
So no final word on this yet?
Not quite yet. The matter is still being heard and it's listed to continue shortly.
Now, this is a story a lot of lawyers and honestly anyone using AI should pay attention to. The Supreme Court has called out the use of AI-generated fake judgments as a global menace. What exactly happened here?
So this started in a case under the Maharashtra Rent Control Act before the Bombay High Court. The court noticed something odd in the written submissions. The formatting, the language, and more importantly, a case that was cited simply did not exist. There was no citation, no copy, nothing. The court and even its law clerks tried to find it and could not. The judge called this a waste of precious judicial time and imposed costs of 50,000 rupees.
And this then went to the Supreme Court
Yes.
too.
The party approached the Supreme Court asking for these remarks to be removed from the High Court's order. Now, the Supreme Court did show some indulgence. It agreed to expunge or remove those specific remarks, but at the same time, it made a much broader point. It said that this problem of citing AI-generated non-existent judgments is rampant, not just in India, but across courts globally. And importantly, the court noted that it is already examining this issue separately on the judicial side. So this isn't just a passing observation.
In a profession where most are overworked and underpaid, what should lawyers keep in mind here?
Very simple. AI can assist you, but it cannot replace your responsibility. Courts have been very clear. If you put something on record, you are accountable for it. If a citation turns out to be fake, the consequences can range from costs to even disciplinary action. At the end of the day, AI tools are powerful. Probably the most powerful research aids we've had so far, but they're not infallible. Honestly, the best way to think about it is, with great power comes great responsibility, and that responsibility squarely rests with a lawyer using the tool.
The fifth story is disturbing. The Supreme Court has summoned the Commissioner of Police, Gurgaon, and the investigating officer to appear in person after calling the investigation into the rape of a 4-year-old child shocking. What exactly happened here?
So this came up before the Supreme Court on a plea by the child's parents, who said the investigation by the Haryana police was completely mishandled. From what came out in court, there were serious concerns. The police allegedly tried to persuade the parents to withdraw the FIR, and the child was repeatedly taken between the police station, hospital, and court instead of being handled in a sensitive way.
The reports also mentioned something about the accused being present when the child's statement was recorded.
Yes, that is the most concerning part of the case. The child's statement was recorded by the magistrate when the accused were in close proximity, which directly goes against basic safeguards in such cases. So the court has now stepped in. It has summoned the Commissioner of Police, Gurugram, and the investigating officer with a full record and also sought an explanation from the magistrate. But this isn't just a one-off. The Supreme Court has in fact already laid down guidelines in 2022 for dealing with what it calls vulnerable witnesses, which basically means children, victims of sexual offences, persons with disabilities, or anyone who may be intimidated or traumatized by the court process.
And these guidelines, I'm sure, prevents the failure of such basic safeguards.
That's the idea. The victim should not have to face the accused directly. Things like screens or separate spaces can be used. Questioning should be controlled by the judge to avoid intimidation or embarrassment, and the entire process should be child-friendly with breaks and support as needed. So when you see what happened in this case, it's exactly opposite of what the law requires.
Now let's move on to the High Courts. Why has Ranveer Singh been asked to apologize before a High Court? And again, at that, that's the controversy coming out of Karnataka.
This goes back to an event at the International Film Festival of India in Goa. During a speech, Ranveer Singh mimicked Rishabh Shetty's role from Kantara and referred to the deity depicted in the film as a female ghost. That led to an FIR under provisions relating to hurting religious sentiments, and he approached the Karnataka High Court to quash the case.
Didn't he already apologize for that on social media?
Yes, but that became an issue in court. The complainant said it wasn't genuine because it was posted by his team and did not show real remorse.
So the court wasn't convinced.
Not entirely. The court observed that what he did was not correct and made it clear a mistake has happened. At that point, his counsel stepped in and offered that Ranveer Singh would file a fresh affidavit apologizing before the court and even visit the Chamundi Devi temple as a gesture of remorse. And that's where things stand now.
And what is the status of the criminal case?
The actor has been protected from coercive steps for now. But the court has clearly signaled that when it comes to religious sentiment, especially with that level of public influence, you're expected to be far more careful.
And staying with the theme of speech, but from a whole different angle from the last story, the Delhi High Court has made a strong point about what universities are supposed to stand for. It says they must encourage free thought, not suppress dissent. Austika, what triggered this?
This came from a case involving a student of Dr. B.R. Ambedkar University who was expelled after allegedly taking part in a sit-in protest on campus. The university said she violated disciplinary rules, but the student argued she wasn't even actively protesting, just present there. The High Court stepped in and said even if she was part of a peaceful protest, expelling her was far too harsh.
So is this really about where you draw the line on free speech?
The court said universities aren't just places to attend classes. They're spaces where students are supposed to question, debate, and think independently. Legally, this ties directly to Article 19, freedom of speech and peaceful assembly. The court said peaceful, non-violent dissent, as long as it doesn't disrupt academic functioning, is part of that right, not a violation of it. It set aside the expulsion as highly disproportionate and said a university that only expects obedience is failing its role.
That's quite a contrast from the previous case.
Exactly, and that's the nuance. Speech is meant to be free and the restrictions on it are supposed to be narrow. But in a country like ours, which is often deeply polarized, speech also carries responsibility. Just as someone has a right to say something, another person may very well feel offended by it. That reaction is also real. But the question is, does every instance of offense need to trigger criminal law? Do we need FIRs at the drop of a hat or universities rushing to punish students? Or is there a more constructive way of dealing with disagreement through dialogue, debate, and engagement? Because ultimately, that's what spaces like universities and a democracy are meant to enable.
Now to a ruling that sparked a lot of debate. The Madhya Pradesh High Court has quashed a charge under Section 377 against a husband, saying consent is immaterial within a marriage. Austika, this needs some unpacking.
It does, and it's important to be precise here. This was a case where a wife filed an FIR alleging cruelty, dowry harassment, and also non-consensual sexual acts, including what were charged under Section 377. The husband approached the High Court to quash that part of the FIR. Now, the court did not throw out the entire case. The other charges continue, but it did quash the Section 377 charge against the husband.
And what was the reasoning?
The court relied on Exception 2 to Section 375, which says that sexual acts by a husband with his adult wife do not constitute rape. It then extended that logic to Section 377 and held that even acts like oral or anal intercourse within a marriage cannot be prosecuted under that provision. Now, legally speaking, this isn't entirely straightforward. That exception exists in Section 375. It doesn't appear in Section 377. So there has been room in law to prosecute non-consensual sexual acts within marriage under Section 377. But courts, including the Delhi High Court, recently have taken a similar view, reasoning that after the 2013 expansion of the definition of rape, many of these acts are now covered under Section 375 itself. And since the marital exception continues there, the same logic carries over. And that leads to a slightly ironic situation. The law today, after the amendment, enhances the protection against such acts outside marriage, but seems to have inadvertently lessened protection within it.
But that language, consent is immaterial. That's what's troubling people.
Absolutely. And the discomfort is understandable because ultimately courts are working within the limits of the statute. The marital rape exception is still very much part of the law. So there isn't much room for courts to go beyond it. But that's exactly why judgments like this reignite the larger debate. Because while the law treats consent in the context of marriage differently, many would argue that it shouldn't. So in a way, this isn't just about one case. It highlights a gap in the law and strengthens the ongoing demand for recognizing marital rape as an offense in India.
And finally, a story that's generated a lot of heat. A Varanasi court has denied bail to 14 accused in what's being called the Ganga Iftar party case. Austika, what exactly is this about?
So this relates to an iftar gathering that was allegedly held on a boat in the middle of the Ganges in Varanasi. The allegation is that the group consumed food, including non-vegetarian food, and disposed of waste into the river, which according to the complainant hurt religious sentiments and polluted a sacred space. Based on this, multiple offences were invoked, including promoting enmity, hurting religious sentiments, public nuisance, and even provisions under environmental law. There is also an allegation that the boat was taken without proper consent.
And based on these details, the court has refused bail.
Yes. The trial court has denied bail to all 14 accused, calling it a serious and non-bailable offence. Now, legally, what that means is the court believes that at this stage, the allegations are serious enough to justify continued custody, not that guilt has been established. Bail decisions usually turn on factors like the nature of the offence, possible punishment, and risks like tampering with evidence.
But doesn't this point towards increasing criminalization?
Exactly. At what point does an act, even if some sections believe it to be insensitive or in poor taste, cross the threshold into criminal liability? This is what we were discussing earlier. And as a corollary, how broadly should provisions like hurting religious sentiments be applied in situations like this?
So the legal issue may go beyond just bail.
Exactly. The accused can still approach the High Court for bail, and those questions may get examined more closely there. But for now, the case sits at a very sensitive intersection: religion, public order, and criminal law. And it's one that will likely be watched very closely.
That brings us to the end of this week's edition of Courts This Week. For detailed reports, access to the judgments, and real-time courtroom updates, visit our website livelaw.in. If you found this helpful, don't forget to follow us on all our socials to stay updated with everything that is law.